24 CR 137, State of Ohio versus Brian Keith Taylor. Are you Brian Keith Taylor appearing there from the jail?
Yes, sir. Yes, Your Honor.
All right.
Just
a minute. Be quiet. This is case number 24 CR 137, State of Ohio versus Brian Keith Taylor. This is a pretrial being conducted by Zoom. The defendant's been indicted on 3 counts of aggravated trafficking and 3 counts of aggravated possession of methamphetamine. Mr. Taylor's attorney is Dennis Kirk, appearing from his office, appearing from the prosecutor's office, Prosecutor Collins. This is a final pretrial. I believe we have a trial date set for April the 7th. Now, I believe that discovery was filed. There's no, Mr. Kirk, did you file a compliance with discovery?
I did, Your Honor.
Okay. Well, we pulled these files last week, so we, actually I see over here there's a red jacket. I see them. Yeah, okay. And then it looks like the state filed an additional discovery this morning with a lab report on it. And you received that?
I did receive that. Yes, my client's not yet aware of it, but I will take that out to him.
All right. And I don't see any pretrial motions filed, or did you file any?
I did not.
Right.
I did not see the warrant for any, so I did not file any.
All right. Now, what's the status of the case then in terms, I know we have a trial set on the April 7th, so that's actually inside the 14-day window, but I believe that this was the best we could do on the scheduling date. So what's the situation here with this case, counsel?
It's protected.
I have made my client aware of his plea offer. We did actually negotiate on that. I have made him aware of the 14-day rule. Also, the form to basically I forget what the technical term for it is, but basically the plea refusal form, gone over that with him as well. He does not wish to sign that form, but has not necessarily stated he wants a jury trial either. He did want me to go back to the state with some additional things, which I did, and they declined to change the offer. So at this point in time, I'm not sure what he wants to do. He's never given.
All right, listen up. Because today's courtroom clip is one of those rare moments where the justice system actually feels like it's running on premium fuel. We've got a defendant sitting in jail, facing multiple felony counts involving meth trafficking and possession. And instead of focusing on the very real possibility of spending years behind bars, he decides his biggest enemy is his own lawyer. And not just any lawyer, a court-appointed attorney who's clearly trying to save him from himself. But this guy? He's convinced he's discovered some secret cheat code to the legal system. You know the type. I read a book, I studied case law, I have motions, and somehow he thinks that makes him more qualified than someone who does this for a living. Meanwhile, the judge in this case? Absolute legend. Zero tolerance. No patience for nonsense. He's not rude, he's surgical. And the longer this defendant talks, the worse it gets, because every sentence exposes just how unprepared he is to defend himself, let alone run a trial. And trust me, the best part is the judge doesn't just shut him down. He explains exactly why he's wrong in a way that's brutal, hilarious, and honestly, kind of educational. So buckle up, because this one is a masterclass in what happens when confidence shows up without intelligence. Next voice one.
So Mr. Taylor, is it, are you rejecting the plea offer the state made and electing to go to trial? Is that your decision?
The process, this process here, this pretrial hearing, I got motions I'd like to file.
Well, you're not representing yourself. You have an attorney. And so,
I know that.
Well, wait a minute. Just wait a minute. I'm going to address this. And under the rule, motions, if you have an attorney, only your attorney can file a motion. So if you prepare something that you want to file, I have ordered our clerk's office not to accept those. They will not accept them because you are not representing yourself. The only way you can file a motion is if you represent yourself, in which case that would be a huge mistake, and you haven't asked for that, and there's be quiet, don't interrupt me when I'm speaking. I'll give you the chance to talk. You just be patient, listen, okay? One of your problems may be that you want to speak instead of listen, and that's a big mistake too. So, getting back to my point is that there's not what's called a hybrid representation system in Ohio, and that's a criminal case. The defendants can't file their own motions. Now, your attorney's indicated that he has reviewed these with you and didn't find anything that had any legal merit, arguable merit that he could file. And under the rules of law, attorneys aren't permitted to file frivolous motions just because their clients think they should. They're the attorneys. They're the ones that know the law. They're the ones that know the rules of professional conduct. They're the ones that are bound by it, not a defendant who wants to file any kind of number of motions based probably on what you've seen on TV or in the movies, which is, again, a real big mistake to believe that kind of crap. So that's where we're at. Now, going back to my question, are you rejecting the plea offer?
Yes.
Yes? Okay, then we will have a trial on April the 7th. All right, so does the state expect this to take more than 1 day?
No, the state expects this to be finished in 1 day.
Okay. Can you agree with that, Mr. Kirk?
I would agree with that, and I would note just for the record, I've been given no names, addresses, phone numbers of any witnesses.
Okay, right here is where you can already see the problem forming. The defense attorney is speaking like a normal human being. Discovery has been exchanged, there were no pretrial motions, and they're inside the trial window. That's how court is supposed to sound. But then you hear the phrase every judge hates. I'm not sure what he wants to do. Because that means the defendant is either refusing to cooperate, refusing to listen, or refusing to accept reality, and all three lead to the same place: disaster. Also notice how the judge is calm and structured at first. He's giving this guy every chance to simply answer one question: plea or trial. That's it. But this defendant is the kind of person who can't answer a yes or no question without turning it into a conspiracy theory. And once that happens, this pretrial stops being a scheduling hearing and becomes a full-on behavioral correction session.
So I don't think we'll have very many, if no witnesses at all.
Well, if there's going to be any witnesses, Mr. Taylor, you have to give those to your attorney so that he can file and respond. Those will due by today. So if you've got them, get it to him right away so he can give them to the state. I'll give you till tomorrow to do that. Now, anything else that we need to discuss in this case?
Yeah, I'm going to ask to have my attorney removed, and I got grounds here. I asked him to file a few motions which are legitimate. I mean, this ain't from TV. This is from going through the law book and studying day in and day out. Everything I've got I got the case numbers, case laws. I got
motion. What kind of motions are you talking about, Mr. Taylor?
Well, one is a motion to suppress. One is, and I got one here. It's motion
to suppress. But this is I believe this is a undercover buy situation, isn't it?
It is 3 buys.
Okay, so I don't know what kind of motion to suppress would be appropriate. What do you think could be suppressed?
It'd be.
Well, if you know so much about the law, I've got an attorney here who knows the law and tells me there's no basis. And now I've got you telling me there is, and I ask you what it is, and you can't tell me.
I asked you to file this motion.
I know that. I'm saying is, what is it you think should be suppressed and why? What's the legal basis for it that you, being a non-lawyer, has come up with that an accomplished lawyer has not?
Got from my paperwork here. I'm trying to be organized here at the same time.
So you have an answer. What is it you would seek to suppress? Pardon me?
I don't know.
You don't know? Okay. Anything else you want to bring up?
I'd like to have my attorney move from the case and have another one, please.
Wait a minute, I'm having trouble understanding you. I can hear you.
I like to remove my attorney and get another one.
Okay, well, you have until April 7th to get yourself a new attorney. If you want to get a new attorney, you can do that. You'll have to hire them because you didn't hire Mr. Kirk. You didn't have the money to hire an attorney, so I appointed him for you. So, he's your attorney unless you get a new attorney. But if you do, they need to be ready to go to trial on April the 7th.
I can't get another board-appointed attorney. I can't afford an attorney.
No, you haven't.
And here we go. This is the moment the judge flips from professional pretrial mode into I've dealt with 10,000 people like you mode. Because the defendant immediately tries the classic self-rep shortcut. I've got motions. But what he doesn't understand, and what the judge explains beautifully, is that Ohio does not allow hybrid representation. Meaning, You don't get to have a lawyer and file your own motions like your co-counsel. You either represent yourself fully or your attorney does it. And the judge isn't saying this to be mean. He's saying it because the court system can't function if defendants are filing random papers they copied from the internet. Courts would drown. Also pay attention to the judge's warning. You want to speak instead of listen. That is the most accurate courtroom diagnosis ever. Because in court, the loudest person is usually the most wrong. Next voice 3. Now this is where the defendant makes his first major strategic error. He asks to remove his lawyer, but he can't explain why. And that matters. In court, you can't just say, I want a new attorney, because you don't like the advice you're getting. That's not ineffective counsel, that's just, I don't like being told no. The judge gives him a wide open runway here. What motions are you talking about? And the defendant immediately throws out motion to suppress. Sounds impressive, until the judge asks the simplest follow-up question. Okay, what exactly are you trying to suppress? And this man has absolutely nothing. No legal basis, no facts, no argument, just vibes. That's the whole problem. He's not being denied a defense. He's being denied the ability to hijack the case with TV lawyer nonsense.
A court-appointed attorney. I've given you a court-appointed attorney.
But he's not representing me.
Yeah, he is. He's representing you, and he's had conversations with you and discussions. You don't like what he's telling you. I get that. If I were in your position, unless they were telling me you're going to walk free and the state's going to give you a written apology and $1 million, I wouldn't be happy either. But, he's not going to do that. So, unless you can tell me why he is not, he shouldn't be your attorney, then you've given me no reason other than the fact that you don't like what he's saying and he won't file motions that aren't proper, which is no attorney would file. So getting you a new attorney would not mean anything, because a new attorney wouldn't be able to file frivolous motions either. And if I gave you any attorney who knows what they're doing, they're not going to do anything different than Mr. Kirk is. Mr. Kirk's been doing this a long time. Now, anything else you want to bring up?
Yes, I have grounds, man. I
asked you what your grounds were, and you didn't tell me anything. You said you didn't know on suppression.
I'm be respectful. Wait till you're done talking.
I'm sorry, what?
Don't be respectful, man. Wait till you're done talking. You got only once for interrupting.
Okay. I asked you to answer my question, and you didn't when I asked you what your grounds were. Now, I'm not going to give you another attorney. If you want to get a new attorney, that's up to you. You feel free to do that. You'll have to hire that attorney. But I don't know who told you that you're entitled to get more than one attorney, because the court has appointed you an attorney. Mr. Kirk is qualified and competent and experienced and knows way more than you'll ever know about the law. So just because you've been in court a few times doesn't mean you know anything about the law. Just because you got a book you can read doesn't mean you know anything about the law. I could read a book on brain surgery, but that wouldn't make me a brain surgeon. You can read a book.
This section right here is why I love this judge. Because he's doing something most judges don't bother doing. He's explaining the logic of the legal system in plain English. When the defendant says, I study law books, the judge responds with the perfect analogy. Reading a book on brain surgery doesn't make you a brain surgeon. That's not just a roast, that's a courtroom life lesson. Because a lot of defendants think legal knowledge is just memorizing buzzwords. Suppression, discovery, separation of witnesses, bill of particulars, counsel eyes only. But law isn't a cheat sheet. It's procedure, strategy, timing, evidence rules, objections, and knowing what actually matters to a jury. This defendant thinks he's being treated unfairly. But the truth is, his lawyer is doing what lawyers are required to do, not file garbage. And the judge is basically telling him, you'll get a fair trial, but you will not get a fantasy trial.
Well, that would be the biggest mistake you've ever made in your entire life, based upon what you've been telling me. I don't think there's any way in the world you could represent yourself. Pardon me?
I haven't been able to tell you nothing.
I can't understand. You're mumbling.
I haven't been able to tell you anything.
Well, you're not the attorney. You're on trial. You don't get to participate in your defense, because that's what an attorney is for. That's why you have one.
But am I allowed to have a fair and just defense?
Well, absolutely, and that's what you're going to get. We'll have a fair trial. We'll have a jury, and we'll have a trial.
don't have all my discovery. I'm missing 12 things that I'm not discovered. I'm begging for.
Well, he's got the discovery. Let me explain here, Mr. Taylor. I met with your attorney and the prosecutors before this hearing, and he kind of outlined to me some of the things you're talking about. As I understand it, you have everything of any importance. I think he said you had mentioned that you didn't have a copy of the resume of the BCI analyst or something, which is minor. It doesn't mean much. He can get that to you. He will get that to you. But the other things that you want, I mean, my understanding, he's given you more than what most defendants get in these kind of cases, because usually there's a counsel-only discovery restriction. But since the identity of the CI is known, apparently they have let you watch the videos, right? You've watched the videos of the what they say are the buys, right? And then you've gotten copies of everything that he has, pretty much. Is that correct, Mr. Kirk?
That is correct, yes.
All right, so I don't know what you're talking about when you say you don't have discovery, because you've got everything that he's got.
Okay, now the defendant has officially entered the danger zone. I want to represent myself. And every time a defendant says that, every judge in America hears the same thing. I would like to speedrun my own conviction. Notice what the judge does here. He doesn't just say no. He warns him repeatedly, and he explains what will happen if he goes pro se. If you represent yourself, you don't get special treatment. The rules still apply. Evidence still applies. Objections still apply. And here's the sneaky smart part. The judge is building the record. He's making sure that later, when this guy loses and tries to appeal saying, "I didn't understand," the transcript will show the judge clearly warned him again and again. This judge isn't just shutting him down, he's protecting the case from future nonsense.